member here, member of the endowment board, so you know, my area of expertise is in estate planning, so you know, I'm here to talk about that and you know, any interest in giving to the church. I'm an attorney at Shaheen and Gordon. It's a law firm in New Hampshire, and again, my primary area of focus is in estate planning, estate administration, and then within that, there's some subgroups that you know I deal with: guardianships, special needs planning, you know, business succession planning, charitable giving. So it kind of has a little bit more to it than just estate planning. So I guess maybe by a raise of hands, how many of you in the room already have an estate plan in place? Okay. So the majority of you, which is great. And for those of you that don't, it's never too late. It's good to you know the benefits of doing some planning. So we'll get into that just now. So I think it's always helpful to understand what happens if you don't do any planning. You know, how would that affect you? And so I kind of look at it in two ways. How will it affect you during your lifetime, and how will it affect you after you pass away? And so, you know, probably more importantly, how does it affect you during your lifetime? If you don't do any planning through appointing persons through powers of attorney to make medical decisions for you, or to handle your finances through a durable power of attorney, the process that your family or loved ones would need to go through is known as a guardianship proceeding. And that's where a court would first deem that you are incapacitated, and as a result, a guardian would be appointed to manage your affairs. There's two types of guardianships in New Hampshire. There's guardianship of the person. That's the person who would handle making medical decisions for you, or would help you know, making the day-to-day decisions. The guardian of the estate would then handle your finances, making sure your bills are being paid and whatnot. It's a horrible process to have to go through. You know, we really try to avoid it, and it's very easily avoidable in many cases. But it's, you know, again, court proceeding, it's costly. It can lead to arguments amongst loved ones as to who's the appropriate person to serve. And it's not going to end with the appointment. The court's going to continue to oversee it, which means the guardian's going to have to keep going back to court year to year. So it's something we definitely try to avoid, and again, there's an easy way to avoid it, which I'll get into in just a moment. And then if you do nothing with regard to planning what happens to your estate upon your passing through, at the very least, a will. If you have an estate upon your passing, then it would be known as an intestate estate, meaning you don't have a will, and so the state statute would then determine who inherits from you for whatever is part of your intestate estate. And it would go through a probate process as well, which I'll go into a little bit more in a few more slides. So first, to avoid guardianship, it's really pretty simple, but maybe the most important, you know, documents that you'll execute. Those are known as advanced directives. The first is a financial power of attorney, where you would name who would make or handle your finances, who pays your bills, who would make decisions for you with regard to property interests, you know, who would handle those day-to-day bills. We typically recommend that you name, you know, a person who you would trust to make those decisions, who's capable of handling your finances, and would be willing, you know, because it can be, you know, a big job depending on what needs to be done day to day. But it's certainly a position that you want to have somebody you trust fill. And I always recommend that you have an alternate as well, because we want to make sure that if the person you named isn't able to serve, then we have an alternate available for that. Similarly, we also recommend that all of our clients execute advanced directives for healthcare, which are a combined power of attorney for healthcare and living will. The power of attorney for healthcare is where you would name who would make medical decisions for you in the event a doctor deems you incapacitated. So again, you want to choose someone who you trust to make decisions that are consistent with your wishes. And then you can also further establish your wishes through the living will portion of the document, in which you can say, I want this type of treatment, particularly with life-sustaining treatment, whether you would want that under certain circumstances or not. So those are very important documents. I always want to make sure those are done first before anything else, and they're part of what we would consider a basic estate plan. In fact, I did bring advanced directives here for healthcare. If anybody is interested, I'd be happy to work with anyone to just fill those out, that simple document on today. Because again, I just think it's that important. So those are those documents that would affect you during your lifetime. To avoid having an intestate estate, there's certain things that you can do, or a couple of different things you can do. So a lot of people don't understand that if they own assets jointly with another person, or if they've designated beneficiaries on accounts, those assets would not be subject to their quote-unquote estate. They would be, handled the way that you directed. If it's a joint account, the asset's going to go to the surviving joint tenant. If you've named a beneficiary, that asset's going to go to that beneficiary. So to avoid that intestate, probate process. But anything else that would not have a joint owner on it, or that would not have a beneficiary name on it, that you would want to deal with through at the very least a will. And a will, you can name who you want to serve as executor of your estate, and you can direct how your estate would be distributed upon your passing. It's pretty limited to just that. Going any further makes things a little more complicated from an administrative point of view, but we'll get into that in a bit. The other option is creating a trust. A trust sometimes is a good way to establish your estate plan. If you wanted to do a little bit more complicated planning than just simply saying this is who gets what, in the percentages. It also will avoid a process known as probate. So I think the next slide goes into probate. But before I move on, does anybody have any questions? This is pretty consistent with what people know already. Okay. So probate. Anybody have experience with probate? Probate process?
With my mother.
Yeah. So people you tend to run into it when a loved one has passed away, and they need to deal with the administration of the estate. And so probate is a probate process to deal with the administration of the estate of the decedent. And it will deal with any assets that are in the decedent's name at the time of the decedent's passing. So, and when I should say in the decedent's name alone. So again, will not cover joint assets, and it won't cover assets that are designated to a certain beneficiary. But it will deal with any assets that are solely in the decedent's name. And the process is you have to submit the will for probate along with a petition that's signed by the named executor or whoever is willing to serve if the named executor is not willing. And then it takes a couple of months for the court to appoint the executor, at which point the court will often require that the executor file a bond with sureties to protect the estate, so it acts like an insurance policy on the estate. That can sometimes be problematic. Some executors cannot get a bond because if they've got credit history, that will be an issue. And then once the court appoints the executor, usually again 2 to 3 months after these days, 2 to 3 months after the petition is filed, there will be additional filings often required, an inventory reporting the assets of the estate and their values, an accounting, sometimes a motion for distribution, sometimes other filings required depending on the circumstances and the assets involved. But the other thing that we always want to make sure people understand is the timing, because once the executor is appointed, you really can't do anything in terms of distributing the estate until 6 months have passed from the date the executor is appointed. And the reason for that is that New Hampshire provides 6 months for creditors to make claims against the estate. So it's known as the statutory creditor claim period. And executor can certainly do things during that time frame, like sell the assets. There's real estate, they can sell their real estate, they can, consolidate the assets into an estate bank account, which they'll need to open as part of the process. But they can't distribute. So it often takes, I would say, closer to a year these days for the estate to be opened and closed and for distributions to finally be made. Part of that is just because of the timing that's required. Part of that's because the court is so far behind in handling these petitions and other filings that are required. So I don't know if anybody has any questions regarding that process, or if that's pretty consistent with anyone's experience that has dealt with it thus far, so far.
Not so much the process, but the line that says wills need to be valid pursuant
Oh,
to
yes.
state law.
Yeah.
So we had wills and living wills in Connecticut, we moved to New Hampshire, we have none.
Yeah.
Okay.
So, wills, if they're executed in another state, in New Hampshire at least, and this is true of many states, as long as they were executed properly within the state that they were executed, they should be valid. But that will require, that will require us though to, in this case, in your case, the estate attorney would need to get, some sort of affirmation from a Connecticut licensed attorney that it was properly executed and it's valid. But yes, I did glaze over that, so thank you for pointing that out. Wills do have to be valid for them to be recognized by the court. So a lot of people might just do, a holographic will, a handwritten will, without, the proper execution requirements, and that's not going to suffice. You need a will to be witnessed by two individuals, for it to be validly executed, independent witnesses, I should say. And they also should be what we call self-proving, to avoid the need for a witness to testify during the hearing as to its execution. And that is, something that we make sure is done when we're working with clients to execute a will. So that's the probate process. The other thing I just want to quickly mention too is that wills are really necessary for the appointment of guardians of minors. So to the extent you have any minor children, you want to make sure you have a will to appoint or nominate guardians for minor children, because again, without that, it can lead to disagreements amongst family members should the horrible thing happen. A lot of people, when I first meet with them, say, I want to avoid probate at all costs. I don't want to have my family have to go through that. What can I do? So immediately what we go through is we'll go through the assets and see how they're titled. Are they in that person's name alone? Do they have beneficiaries named? Are they joint? Again, if they're joint or they name beneficiaries, those assets will avoid probate. But to the extent that you can't do that with a particular asset, often that's the case with real estate, for example. You can't name a beneficiary. It may be joint with your spouse, but if you want to avoid that process upon the first or surviving spouse's passing, it's hard to do. So the other primary method of avoiding probate is creating and funding a revocable trust. It's a good way for avoiding probate, and it acts like a will substitute in that the revocable trust says this is how my estate is going to be distributed upon my passing. It also allows for further planning opportunities. So, if you didn't want to simply say I want everything to go to, my children outright with no restriction, you wanted to do some other planning or had some particular plans for a particular asset, a revocable trust is a good vehicle to use that for. Because doing that under a will means the court's going to have to oversee it, and that can lead to complexities and costs. So yeah, a revocable trust is a good way for probate avoidance. It's something we look to often if that's the client's, one of the client's objectives. One thing I want to mention about joint accounts just quickly is that a lot of people will, come in, a lot of my, initial clients will come in and say, oh yeah, I have my account joint with my child, that bank told me to do that so that upon, if something happens to me, they have access quickly, and that is true. They would have access, but what I think sometimes the banks fail to tell the clients, is that the joint owner, if it's a child or whomever, is going to become the owner of that account upon your passing. So they don't have an obligation thereafter to use those assets in the joint account for your expenses, to share with other family members, be it other children. So it may not be an issue, but sometimes it is, and I think it's just good to have that clarification. Okay. So, you know, we often say to clients if they do estate planning to try to review it every 3 to 5 years to make sure that it's consistent with their wishes. If there's been changes in the family, divorce, death, you know, that might mean that there's a requirement for a change. If there's certainly a change in how you want your estate to be distributed, then we want to see you to make sure that your objectives are being met. Okay. Another thing I want to just touch on a little bit is taxes, because everybody worries about death and taxes. So New Hampshire no longer has an estate or inheritance tax, and other states do, but the federal government still has an estate tax, which is combined with the gift tax. So they take a look at your combined lifetime gifts and you value your estate. And if your estate exceeds almost 13 million in 2023, then you'll have a taxable estate for estate tax purposes, which really doesn't affect the general population anymore. But I just wanted to point it out in case that was something people had questions about. If that does affect you, then good for you. And married couples can actually exempt up a double that figure. Though that figure, I should mention, is going to be reduced down to about half in 2026. So in 2026, due to legislation that was passed in 2017, that exemption figure will go down from about 13 million to about 6.5 million per individual. A married couple, again, would be able to exempt double that. The other thing I want to mention is that for gift taxes, a lot of people will come to me and say, I want to make a gift, but I don't want my beneficiary to pay taxes on the gift. You can give, in 2023, the figure that you can give without having to worry about gift taxes at all is $17,000 per beneficiary. So, if it's a married couple that wants to make a gift, they can double that, to one person. But even if you gift above and beyond that amount, you don't necessarily have to worry about paying gift taxes. It's only if you gift, over 13 million that gift taxes would be due. So it's usually not an issue, but I just wanted to mention it because a lot of people, again, have questions. I don't want my beneficiary to pay gift taxes at all. The only obligation, if you gift over 17,000 in 2023, 16,000 this year, is that you would need to file a gift tax return, which is a simple document. Other states have an estate tax, so we just want to touch on that. Other states in New England, every other state in New England has an estate tax. So that is applicable if you own real estate in another state. So for example, if you own real estate in Massachusetts, their estate tax exemption is $1 million. So if you have a gross estate of over $1 million and own real estate in Massachusetts, your estate may be subject to Massachusetts estate taxes. So, and that can be true of other states. Massachusetts is usually the one that we see that most often with because their estate tax exemption is so low. Anybody have any questions about estate taxes before I move on to estate and gift taxes? I kind of wanted to just mention it before.
Just the second bullet about
Sure.
gift, is that on death or is that?
Nope.
Can you give, when you're alive, you can give?
You can give during your lifetime. Yeah, that's the lifetime gifting. So there's an annual exclusion amount that you can gift over your lifetime, which is in 2023 will be 17,000. It's currently 16,000. So if you gift that amount, that doesn't eat into your exemption of 13 million. If you gift over that amount, it does start to eat into your exemption amount. And it's only at the point where you give 13 million or more, beginning January 1, that you will then have to pay gift well, there will be gift taxes that become due. Okay? Any other questions? Okay. Just to kind of touch on these before we move away from taxes. The executor trustee of your, or trustee of your estate will still need to file your final personal income tax return and will need to file your state income tax return, or will need to file an estate income tax return or a trust income tax return to the extent the estate or trust has earned any income. We try to avoid that because that's a nasty tax rate.
I have a question.
Yes.
You mentioned if you're in real estate in another state,
Mhm.
then that state's estate tax rules apply.
Yep.
Even if you're living in New Hampshire where there is no estate tax.
Correct, because if you own real estate, that real estate is subject to the laws of that state. And so, again, I'll use Massachusetts as an example because I'm licensed in Massachusetts too. The way it works in Massachusetts is that if you, we'll just use an example, if you have property on the Cape that's worth $400,000, and but you live here and your estate is otherwise, $800,000. Between the two, your estate is over $1 million. So you've reached that figure. They're going to tax your estate based on the proportionate amount that's sitting in Massachusetts. Yeah. So it's not as large, but it's still something to think about.
And also, as regards living wills and advance directives, so if someone moves here from Connecticut
Mm-hmm.
and they have an advance directive that was executed in Connecticut, how enforceable or usable is that here in New Hampshire?
It's enforceable, but I always recommend that people, when they move from one state to another, to execute at the very least new powers of attorney, just because the state's laws differ, and particularly with the healthcare directive, the healthcare facilities seem to be familiar with the local documents as opposed to, foreign documents. So that's always my recommendation, that we at least, it's not that they're unenforceable, but it might create a complication for the person you've named in getting it recognized or doing what they need to do. The other thing I should mention with powers of attorney, financial powers of attorney, is that I often recommend that they be done every 5 to 10 years. And that's not because an older power of attorney is unenforceable, it certainly is, but some financial institutions take the hardline approach that if it's an older document, they don't want to recognize it because they don't want to take the risk that you'd executed a document in that period in between. And so again, it's not that it's not enforceable, but it might take some work to get that, recognized. So our goal is to make, your fiduciary or agent's job easy. And so that's our recommendation there too. Any other questions? Okay. Before I move on, so with taxes, the other thing to consider is income taxes. Income taxes are not usually too much of an issue when it relates to an estate. Most of those assets will pass income tax free. The exception really often is for qualified retirement accounts, 401ks, 403bs, IRAs, the traditional kind, I should mention, not Roth accounts. Just as they're taxable to you when you withdraw from those accounts, they're going to be taxable to your beneficiaries. Whatever they withdraw from the accounts will be considered taxable income to them, and they will only have 10 years to withdraw from that account from the date of your passing. So they will pay a percentage of whatever that account value is in income taxes. So some charitable giving considerations. If people have charitable, want to make some charitable gifts, there's different ways to do that. Sometimes people want to do that for purposes, have the additional purposes of reducing income taxes or reducing estate taxes. If you make a charitable gift to a charity, such as the church, for estate tax purposes, that's going to get an estate tax deduction.
Would you say that again about giving something to the church?
Sure.
Oh, come on. You knew that was coming. You don't get free cookies for nothing.
So if you make a gift to the church, as part of your estate plan, you make that bequest within a will or a irrevocable trust, that gift will get a charitable deduction for estate tax purposes, okay? But if estate tax purposes maybe aren't, if charitable giving, you want to accomplish other tax savings, maybe because estate taxes aren't an issue for you, but income taxes are, there are ways to do that too. So I had mentioned just before that those qualified retirement accounts, those 401ks, IRAs, there's other vehicles, but those are the main kinds that we see. Those accounts, as I said, are going to be taxable to non-charitable beneficiaries, except for maybe, they will be to a spouse, but the spouse has more options. So, if you were to name, a child, for example, as a beneficiary on that account, they will have 10 years to withdraw from that account, and all of those withdrawals will be considered taxable income to them in that year, and as a result, they'll pay taxes on it. So if you have, say, a $500,000 IRA, it's not really $500,000 to that beneficiary. So if you want to make charitable gifts, that's a great place to do it, because the charity, unlike a beneficiary, is not going to pay taxes on the distributions. They're going to get that tax-free, so your money goes a little further. So I often talk to my clients about making any charitable gifts to the church, for example, through their retirement accounts, because I'm seeing these days that those retirement accounts are people's primary savings, where their primary savings is other than their home. So, and the other benefit to it is that you don't have to pay me to make that change. You can simply do that with your custodian of your retirement account. So that's a good thing to do. Those are often strategies that we're working with most of our clients on in accomplishing their charitable objectives. First looking at retirement accounts, let's find a tax advantageous way to make that gift. And if they want to go above and beyond that, which is great, then we're going to go and look at doing it through their will or their trust. Okay. But there's other ways to do it that are a little more complicated, but worth mentioning. There's vehicles known as charitable remainder trusts, charitable gift annuities, charitable lead trusts. And all of that, all of those, in one way or another, accomplish the goal of making a gift during your lifetime to a charity of a portion of your estate while retaining some interest during your life, or leaving some interest to another beneficiary, but giving a larger portion of the interest to the charity. So it's a slightly more complicated vehicle to use for that objective, but it's available. So if anybody had any interest in doing those sorts of plans, I'd be happy to talk to you more about it. But I think I would just say again that the tools that we often use more often are the retirement accounts, life insurance policies too, maybe charities on as beneficiaries on life insurance policies, and then using the will or trust to make charitable requests. And I also just want to touch on long-term care planning, because it's such a consideration and concern that people have when they come in to do their estate planning. So long-term care planning is kind of another subset of estate planning, and it really deals with individuals who may need or are anticipating the need of nursing home level care, whether at home, in the community, or in a facility. And so I just kind of like to describe what that entails and the different options that are available first. So if you were to need long-term care, and we'll just use a nursing home as an example, the dreaded nursing home. If you needed long-term care in a nursing home, maybe you had been discharged from a hospital and need rehabilitation services. Medicare will cover your care there for up to 100 days, at 100% for the first 20, and then at 80% for the remaining 80, but only so long as you need rehabilitative care. Once that rehabilitation is no longer necessary, and that's determined by the physician or the medical providers at the facility, then it turns to private pay if you need to stay. And private pay means you're paying from your private resources. That can include long-term care insurance if you have it. But then the expectation is that you would use your other resources to cover that care. Once those resources have been exhausted, then Medicaid comes in. So Medicaid is the payer of last resort. That's a jointly funded state and federal program that's administered by the states. So each state does a little differently. New Hampshire, for example, if an individual needs that level of care, they're only going to be eligible for Medicaid if they have less than $2,500 in their name and do not have an income that would be otherwise sufficient to cover the cost, and then they haven't made transfers for less than fair market value within the 5 years of filing an application for benefits. So it's really limited to those who are very, very, very needy. The rules are definitely different for married couples. Married couples can protect more for the benefit of the other spouse. The other spouse can retain the home as long as they're living there, and they can retain up to $140,000 in other assets. Above and beyond that, they can do other plans to make sure their everyday needs are being met. So those are the ground rules. If there was a desire to do some other planning to try to protect assets, we always think of that 5-year rule. Are we going to try to make transfers? And if we are, we need to do so 5 years before there's a need for care. It's known as the 5-year look back rule. So a lot of people will say, or they'll come to me and say, I heard this commercial or heard something on the radio that if I put my house into a trust, there's no need, that's going to be protected. And it really depends on the type of trust that you create. So a revocable trust, the one which I described earlier, is not going to provide that protection. And the reason is that if it's a revocable trust, by its very term, you can revoke it. So you can take money out, you can terminate the trust. Oftentimes in a revocable trust, you're also the trustee, you're also the beneficiary. So the state takes the position that if the funds are available to you, because you can revoke the trust or because you're in control of it, then it's available to pay for your care. So the type of trust that you would be looking to do is what we call an irrevocable trust, and it's one in which you would have limited interest in order to have that protection. In order to get the protection, you have to give up a little bit. So I just wanted to mention that because there is some confusion on that too. I often find people come in and say, I have a trust, so I'm all set. But if it's a revocable trust, it's not going to be the type of trust that provides that protection. So,
now, how much is your estimate that the nursing home costs now if you run out of the Medicare?
yeah, it depends on the facility, but it's like $12,000, I would say, a month.
$12,000 a month, and that's privately paid.
That's
by-
private pay.
I think that's kind of low.
It can be. I'm kind of going on a state average.
Yeah.
Right.
There's definitely going to be higher probably the more south you are, and lower the further north you go. It depends from facility to facility. Assisted livings, are coming up to that price too, especially if it's a memory care unit. So it's something definitely to think about. I always talk to clients first about consider long-term care insurance if you're really worried about this. Though that it's at least worth looking into. It may not be appropriate or it may be too expensive, but you don't know until you look into it. So, and then there's other great programs. Riverwoods is another great place that provides good care. It's sort of an alternative to any of this. So, any other questions?
Yeah, I was just I couldn't overemphasize more the importance of long-term care planning. Recently I was holding my sister's hand as she was considering this for her husband, and the options are not great. She did have a long-term care insurance plan, but she was faced with a 90-day waiting period.
Mm-hmm. Yeah.
And the expense of long-term care is very high, and that would have been almost prohibitively expensive.
Mhm.
My wife and I have a combination long-term care insurance plan, which would kick in immediately, and we can also share the proceeds. So,
Oh, okay, great.
it's a higher premium, but on the other hand, I think there are some great benefits. But as I say, I think this is something we tend to forget
Mhm.
until we're confronted with it,
Mhm.
and then we're sort of shocked by
The reality.
both the expense, realities, exactly. The
Yeah.
expense and there's a big gap in our medical system when it comes to post-acute care.
Yeah, it's not a great system, but it's a system we have, so we try to.
No, I realize.
It's a plan, having a plan in place is always good. And I think, my approach has always been, at least look into the long-term care insurance, because I don't want to necessarily plan you into a nursing home bed that's Medicaid funded, because that's limited in terms of options too. It's a shared room in a nursing home. So, it's appropriate in some cases, but I think it's always worth looking at all of the options on the table. So, any questions?
Do you have an estimate of cost of long-term care insurance, or is it really vary?
It really varies because there's different vehicles. There's traditional long-term care insurance. A lot of insurance companies have actually gotten out of the market because they found it not to be a very profitable enterprise. But there's different other types of policies. Hybrid policies have been the trend recently, where it's like a hybrid between a life insurance policy with a long-term care rider that you can dip into. So it really depends on your needs and capabilities. But talking to somebody about it is better than talking to somebody, a financial advisor or an insurance provider of some kind. They'll give you better information. But I always like to loop them in when this type of concern comes up.
I'm always in the work of encouraging people to make wills. There's that little line in the e-news that I quoted from the Book of Common Prayer that calls upon the clergy to remind people to make a will and to provide for children, to name guardians there. Do you have any idea of the percentage of people who have no will? And then what do you think are the impediments of what is the reason? I have my own theories, but
Yeah.
in your work, why don't people do it?
I think probably it's high. The percentage is probably close to 70%.
Okay.
That do not have any estate planning documents in place. I think that people don't want to think about death. That's one reason. It's not an easy subject or a nice thing to contemplate. So that's a huge impediment that I find. But the cost is there too. I can't deny that. I don't try to make my costs astronomical, but it's still, I have to turn the lights on or keep the lights on too. So there is a cost involved. I think those are the two impediments. And I think the other is that people don't really realize the need for it until they've experienced it in some form. If they've had to deal with somebody's estate, if they've had to deal with guardianship, that's when I often see people that are coming in, I had this horrible experience, I want to do everything possible to avoid that. So I think people don't know what they don't know.
Yeah,
Does that make sense?
it does.
Yeah.
Yeah.
Any other questions?